Thank you, Mr. Chairman. Mr. Berner, you sent an email to Francis and Susan, and I believe that's Susan Richardson and Francis. I apologize, I can't pronounce her last name. Is that correct?
That's correct, sir.
Can you pronounce her last name for me so I can get it right? If you can't, it's okay. I understand.
I could try, but I'll apologize to Francis formally, but Nwachuku.
Nwachuku. All right. And you wrote that to both of them on February 10th. You got a message back from Francis on that same day that says there's been a gross misunderstanding. Is that correct?
That's correct, sir.
And then on February the 11th, you got a OMB circular from Francis. Susan does not appear to be on this. Is that correct? Which says, and I don't know where we are, somewhere, I don't know where, I can't keep track, I don't have tabs, so I have to try to figure it out by counting, and it's something I'm not good.
There's an excerpt from an OMB circular that Susan sent.
And that says, workouts, do you have a copy of that in front of you?
Yes, sir, I do.
Okay, and that says, does it not, that workouts mean plans that offer options short of default? That's the first phrase, is it not?
Yes, sir.
And then it goes on to explain that that's not modifications. That's not a modification at the very end. Is that correct?
That's correct, sir.
At the time that you received that, you were not aware of the legal memorandum that DOE had that Susan Richardson was in draft form and then later on February 15th became a formal form, at least according to what we have today. You were not aware of that legal memorandum. Isn't that correct?
That's correct, sir.
And notwithstanding the fact that you were getting data or a copy of an OMB circular from Francis that said that, let me quote that again, that said workouts mean plans that offer options short of default, and what she was basically saying to you was, we don't think that we're modifying this loan or we're doing something that would create the necessity to consult with you all. Isn't that correct? That was the purpose of these emails and conversations. We don't believe that we're making a change that compromises the taxpayer's position. Isn't that correct?
As I recall, that's what they were saying.
That was the general demeanor. And yet, they're sending this to you on February 11th, but these memos that we had the big fight about today are dated January 19th, and as I pointed out in my comments earlier, first line of the third paragraph, and I know that you don't know anything about this, but I'm just pointing it out to you, a default relating to a financial requirement has occurred under the loan guarantee agreement in relationship to Solyndra. Is there any way in your mind that Francis wouldn't have known that the legal opinion was already rendered that said that there had been, in fact, a default, but now we're going to try to fix it, when she's trying to tell you that workout means plans that offer options short of default?
I can't comment on what Francis
Can't comment on that. And further, it is, in fact, you know Peter, B-I-E-G-E-R?
Mr. Bigger, yes.
Mr. Bigger. And Mr. Bigger is an attorney, is he not?
He is a staff attorney at the Treasury Department.
So he works with you all?
Yes, sir.
And subsequent to that, are you aware that he stated in a memo that claim compromises include loan workouts? Are you aware of that? And again, I can't tell you what tab that is. You know what tab that is? I'm back out here on Mr. Bigger's August 17, 2011 memorandum. Authority to compromise, it's titled Authority to Compromise Claims Owed to the Government.
Okay, it's the first time I've seen this memo, sir, but it does say that.
It does say that, does it not?
Yes, sir.
Yes, it does. And so I would have to say to you, based on the evidence that you now know, that there was a subordination of $75 million, that it appears that in the restructuring they may have agreed to forbear payments totaling $30 million for 3 years, wouldn't you agree that those terms sound like a substantial change under the regulations regarding this loan guarantee program?
Substantial change. It was certainly a change, sir. Whether it's substantial is a, I think.
But it would be your opinion, would it not? And I'm asking you for your opinion.
That's really something that the Department of Energy would have to answer, it being their statute and indeed their program. And
well,
Treasury would not have offered, and even in these emails is not offering any legal interpretation. It is citing the statutes only.
So if they had agreed just to completely forbear the entire loan, it wouldn't matter they didn't discuss it with you if they decided it wasn't a substantial change? Is that what you're saying?
I'm saying that I personally am not a lawyer, couldn't render that judgment, and it's not the Treasury's role institutionally to render that judgment for DOE.
So what's the purpose of having you in the loop if you have no authority? Thank you. Yield back.
Thank you. I ask unanimous consent for Mr. Pompeo to be